And people define guerrilla tactics in different ways, and there are obviously some questions about what guerrilla tactics really covers. Bill Rowley, so William Rowley actually has a chapter in one of his books, or a contributing chapter to a book actually called Guerilla Tactics in International Arbitration, which is published in the International Arbitration Law Library. And this is extracted from that, where guerrilla tactics is actually defined in these different ways. So one is to exploit procedural rules for their own advantage, seeking to delay the hearing, and if they get any opportunity, ultimately to derail the arbitration so that it becomes abortive or ineffective. So that is one of the definitions. It's also been seen to encompass strategies employed by parties to arbitration proceedings that are ethical violations or involve criminal acts or ethically borderline practices. And actually, I'll deal with these different angles from which guerrilla tactics can be seen or assessed or identified. And finally, it also deals with, or it also defined as strategies, methods, and tactics ranging from poor behavior to egregious and even criminal conduct. Now, I just wanted to share with you briefly what Naveen's definition is in his thesis when he started writing about guerrilla tactics. And actually, it's the last thing he did is ended up defining what this phrase actually means. And his definition is that the use of guerrilla tactics in international arbitration essentially corresponds to the utilization of apparent strategic misconduct that may comprise an element of surprise to ultimately shift power from one party to the other in their legal battle. So the aim of guerrilla tactics is often seen as, if you don't have, or not relying on your substantive case often, but using tactics to sway the matter in your direction. So let's have a closer look at what actually the definition is about. Thank you, Jahi. So guerrilla tactics, as I said in the previous slide, citing Bill Rowley, it's not limited to illegal acts. So it doesn't mean that if something is called a guerrilla tactic, it's by definition barred, or a conduct that offends some law or policy or regulation. On its face, it may also include maneuvers that are actually legal. And that's why we categorize them into different sort of elevation tactics. So tactics that are ethically borderline. So that's the first category. So rough riding or ethically borderline. Subtle guerrilla tactics. So sometimes actually you may just see it as procedural tactics and not really something specific that one would be able to identify as a guerrilla tactic. But sometimes it's very blatant, and you have extreme guerrilla tactics. Sorry, that's meant to be category 3, where you have extreme guerrilla tactics. And I'm going to cover, as I say, some examples of each of these. In terms of the prevalence of guerrilla tactics, so what we've seen, particularly in the arbitration context, is parties really sort of identifying this type of tactics and complaining about them. So there was actually a survey conducted by Professor Edna Sussman, who's very well known in arbitration, in 2010, where what she found is that 66% of the respondents that she was that were involved in this survey, so about 81 respondents, they'd reported that they had experienced guerrilla tactics, or what were, in their opinion, guerrilla tactics. And sometimes this conduct may just be normal conduct in a procedure in a particular jurisdiction, but in the arbitration context is seen as, offensive or rising to the level of guerrilla tactics. So what do we mean by that? So how does a tribunal look at a certain conduct and say, is this just normal conduct which a party has by way of right? Is it something that is innovative conduct by a party, or does it give rise to this term, guerrilla tactics? And I think what it comes down to is the tension between the tribunal's mandate to conduct the proceedings efficiently. So, parties may ask for extensions, continued extensions on things, and I'll take you to that in a moment, and some examples of that in the procedure of an arbitration, or parties may find other ways to derail arbitration proceedings. So the tribunal has an obligation and a mandate to say, no, I'm going to conduct this arbitration efficiently, cost effectively, and time effectively. And sometimes this mandate is not just as a matter of their procedure or in the institutional rules, but it's actually also provided in statute. And so they really have to know that they're fulfilling that obligation. But balanced with that is the opportunity to each party to present their case. So giving each party that opportunity. If you don't, as a tribunal, then your award might be vulnerable to either not being enforced or challenged even on the basis that a party didn't have a fair opportunity to present their case. And this ground of the fair opportunity, of course, comes from the New York Convention. So how does one balance that? And how does a tribunal ensure that its awards are effective, but also in compliance with either mandatory law, procedure, or their mandate by contract? The other problem with this term and how to deal with this term, how to sort of identify and combat guerrilla tactics, is the fact that there's really limited public information available. Why is that? That's for the obvious reason that arbitration is confidential. So we don't often get to see how tribunals address a certain tactic, whether or not when their patience is tested, where do they stop? How do they prevent such tactics? Do they use cost sanctions? Do they use specific enforcement or orders, for instance? It's not clear because often we don't get to see. In courts, sometimes even the procedural orders are available on the website and you can sort of pull everything up and work out how everything's going. But in an arbitration, you don't have that privilege. So of course, the lack of visibility also makes this a very gray area and an area of concern for international arbitrators. And then this is something I'll come on to at the end as well, is there's a great perception of the lack of effective sanctions. So parties generally tend to think that they fear courts, but they maybe fear arbitrators less. And until an arbitrator's order elevates to a court order or is reinforced by a court, well, do I really need to follow it? Or can I just disregard a direction or an order by a court, by a tribunal? So and I should say that the MCCI rules as well have in Rule 14, it's subject to some other rules, but what it does say is that the tribunal shall conduct proceedings in such manner as it considers appropriate, unless otherwise agreed by the parties. The tribunal will, however, provide effective hearing and opportunity to all the parties consistent with the rules and, importantly, principles of natural justice. So this really goes to the point about the tribunal has this obligation to give the parties the opportunity and natural justice in the process, but at the same time, it has discretion to decide how it will conduct these proceedings. So how do you balance those two, what I call sometimes competing objectives? Just one thing I'd like to say here, which is on the right side of this slide, is some of you may know the Queen Mary survey. So Queen Mary University of London conducts an annual survey, and actually it's come to be seen as a very widely regarded survey of arbitration users and really what they face and how they rank, arbitration as an effective means of dispute resolution. And what the 2021, so the most recent survey showed, is that 21% of the respondents to the survey considered that institutions should adopt rules giving extensive case management powers in relation to arbitrators, including robust sanctions in relation to the behavior of parties and of counsel. And this is to make it more attractive for users so that users of arbitration do not feel that actually arbitration is just not as effective in its procedure. And even some older surveys, so the 2019 survey on international construction arbitration, which is again another reputable survey, said that 53% of respondents considered that party tactics, of course they don't say guerrilla tactics, but essentially it's one and the same thing, I would think, party tactics contributed to inefficiency of the process. A 2018 survey also lamented the lack of effective sanctions during the arbitral process as the second worst feature of arbitration. Now, that's really interesting because there's a lot of other things that people do complain about in arbitration, and there's a lot of things that people like about it. But when we focus on how we can improve the process, then what people are saying is tribunals just need to be more forceful in how they identify these tactics and how they combat them. So when I talk about these tactics, what do I mean by that? Let me take you through a few categories that I've identified. And what I'll do is deal with some of these in more detail than others. But there's some by which I'll use some case references to take you through what happened, just to make it a little bit more real for you on how these tactics are deployed. And some of that is my own anecdotal experience from my practice, which I thought it might be useful to share. So these are the 6 categories. So there's document production and disclosure. This is in a separate category of its own because it's really a prevalent way of parties seeking to derail arbitral processes. And again, I'll talk about it in the next slide a little bit. But essentially, it involves sort of parties using the disclosure part of an arbitral process to try and either delay things, hide documents, or just not disclose documents. Delay tactics. So this is, counsel or parties citing reasons for not being able to attend hearings or not abiding by timelines. Creating conflicts. Now, this is, again, something that I will spend a bit of time on. The conflicts, what do you do in a situation of a perceived conflict? Can you challenge an arbitrator? How often do we see challenges? But conflicts are also imposed sometimes on counsel, and those are harder because everybody has a right to their choice of counsel. But of course, in the same vein, if the other side comes and raises an issue with conflict to do with counsel, then how does the procedure go forward without some threat to the decision later on? This 4th one is a fairly new one. So pandemic-related tactics. Delay witness tampering, citing the impairment to the right to present its case. So these are tactics that we have seen that are pandemic introduced. So essentially, as a result of COVID, people have come up with and are citing, some of these may be legitimate, but we're seeing reasons cited as a result of COVID that that sort of sometimes fall within the definition of guerrilla tactics. So the first is just a couple of examples to dwell on that for a minute. The first example that I've seen is jurisdictional challenges to avoid a virtual hearing. So as you know, we've all gone virtual for the last 12 to 15 months. And I myself have been through quite a number of matters where the idea of a virtual hearing is cited as a reason for not proceeding with the hearing or for staying the matter for some time. Of course, the problem is there's no foreseeability of when hearings may be physical again. So to what extent are parties actually trying to continue the matter virtually versus just sort of putting their hands up and saying, no, this is impossible. And again, this is not something that's black and white. There's a real spectrum. There's a lot of case law in courts on how effective can be virtual hearings or when are there situations where a virtual hearing is ineffective. But that is something that gets cited. A party may try and argue quite outrightly to say that they are being treated unequally to avoid a virtual hearing and or to delay. So just to invoke this point that the tribunal is not treating the parties equally. Then there is the inability to present one's case to avoid a virtual hearing or to delay. That's again cited as a reason for not turning up to a hearing. One other problem that we have worked out is, or we have faced, is the idea of witness evidence. So do you let witnesses give evidence without actually having checks and balances around where they're sitting? Is there any counsel in the same room? Is it okay for counsel to be in the same room? And this is a problem, in terms of how we can ensure that not only are you heard, but there's no other derailment in the fairness of the process that might challenge the tribunal's decision. So those are some examples of pandemic-related issues that I don't think we'll see going away anytime soon, I'm afraid. But then you have privilege challenges to arbitrators. So again, this is something I'll deal with. And finally, and this is a really important one, is local proceedings. So you often have local proceedings as a way of, stopping the arbitral process or creating a derailment to the arbitral process. There are some other commonly cited or commonly seen examples. One important one is ex parte communication. So often what you'll have is a party communicating one-sidedly with an arbitrator, which is obviously not conduct that is seen in a good light. And again, being sort of temperamental in proceedings, so being very, I guess, oppressive towards a tribunal member, not challenging the tribunal member, but being oppressive towards the tribunal member such that it's obstructive to the continuity of the hearing, and that kind of conduct. So there's a whole host of them, but these are just the ones that I wanted to highlight. So let me talk about some of these examples. So these are what I would call the rough riding or ethically borderline types of guerrilla tactics. So I mentioned document requests. So sometimes what you have is excessive requests, and a party just cites lots and lots of document requests, which is part of the disclosure phase of an arbitration, and the other party has no choice but to fight them, and a tribunal has no choice but to decide on them. And so what you find is often that leads to time extensions, and often that leads to very onerous disclosure requirements if those requests are actually granted. Another one, and I've actually seen in my last 5 arbitral appointments, 2 of them were actually terminated owing to the failure to pay a deposit. So when you start an arbitration, you have to pay a deposit to the institution right at the start of the arbitration. And what parties will sometimes do is they will turn up and they will simply not pay. And there are rules around this that make it actually impossible. So either the institution or the tribunal at some stage will say, no, I'm not going to allow that to proceed because you have failed to pay a deposit. Another one is failure to produce documents. So again, this is related to document disclosure. And even though you are given very onerous document disclosure orders by the tribunal, what I've seen is that when you have certain types of counterparties, either they don't have the same document system as your client, so they just don't keep that many documents, or they just choose not to disclose. So I've actually had one situation where we disclosed 7 volumes of documents, so 7 files, and the other side disclosed 7 sheets of paper. And you can see the divergent sort of disclosure that came out of both sides having been faced with lots and lots of document requests. The only other one I wanted to mention here is on the other side, on the left side, which is the late filing of submissions. Now, late filing of submission or evidence, so introducing evidence for the first time at hearing, these are matters which, again, I've seen quite a lot, and often what you have is evidence served the night before, and parties sort of not knowing what to do. Does it need is the submission filed very, very late or the night or 2 nights before a hearing? Can you go ahead? Or does the tribunal need more time, if not the party, to consider that submission? So again, it isn't very clear, those situations. And in some ways, if there's genuinely new evidence that has come through, then obviously there is an ethical reason to file last-minute evidence. And that's why I say these are ethically borderline reasons, but often they're used with not very good intentions behind them. So let me now go to something a bit more extreme, perhaps. So sometimes what you see is illegal conduct, and it's more common, I would say, in investment arbitration. I suppose the stakes are higher when you have investor-state matters, or the state sometimes has more control over certain political tactics or local tactics that you're able to deploy as a state, which, of course, ordinary commercial parties cannot. So I've certainly done my share of cases where you have issues of bribes, or forging of documents. I actually had a case that at the very last minute, there's an issue of forging documents that came up, and it wasn't clear what we had to do with that. And of course, what should the tribunal do? Do they need to decide at that point, or do they have the right to say, I'm going to put that aside? We then have, intimidation of parties, witness, counsel. So the case Zelensky, which I've cited there, where death threats were allegedly made by the chief executive of one of the parties, so of Zelensky, a Russian buyer, against the director of the other party, a Canadian party called Donaldson Livestock International. And what was being alleged was by Donaldson was that those deaths prevented Donaldson participating in the arbitration, and therefore that award would be contrary to public policy. But actually what happened is that the court found that the allegations were unproven of these death threats, and they were insufficient to override the obligation to participate in the arbitration. So sometimes, even if there's evidence, a court or a tribunal may find that actually you could have overcome that. So it wasn't a genuine guerrilla tactic that could get in the way of the process. There's a very well-known case of 1999 called Himpurna versus Indonesia, and this is an UNCITRAL arbitration seated in Jakarta. There's an Indonesian state-owned company who actually obtained an injunction from the Indonesian courts ordering the suspension of an arbitration, of that arbitration. And there was a fine of $1 million a day if the arbitration proceeded. The tribunal moved the hearing venue to The Hague to proceed with the arbitration. But later, what was found that one of the Indonesian arbitrators couldn't attend the hearing. And he later recounted that when he arrived at The Hague, he was prevented by Indonesian officials from participating in the hearing. And there were agents who arrived at Schiphol Airport in Amsterdam 2 days before the hearing to escort him back to Jakarta. This case is actually really well known on truncated tribunals. So do the tribunal as a two, if they lose one member for any good, very valid reason, do they have the power to proceed as a two? These are, I would say, as I've said, extreme tactics. You don't see them a lot, but when you see them, they really do make headlines, and they beg questions about how does one deal with those, and what does one do with the arbitral process? I mean, in the case of Himpurna, they went on and rendered an award because the tribunal decided they could proceed as a two-member. The next one is, I mentioned that I will deal with arbitrator challenges a bit more. So frivolous challenges is something that we see quite a lot. Either we read about it or we see it actually happen. Now, just to talk a little bit about challenges to arbitrators, I won't be on this slide for very long, but essentially you challenge an arbitrator. The basis, sort of globally speaking, is on impartiality and independence. So if the arbitrator has some basis, if there are any justifiable doubts, that's usually the test on their independence and impartiality. And this is the same in the Madras rules, by the way, on Rule 11, that if there are circumstances that exist that give rise to justifiable doubts on the arbitrator's impartiality or independence, or the arbitrator doesn't possess the requisite qualification that the parties have agreed, then its sort of role on the tribunal can be challenged. There are other grounds like incapacity or failure to conduct or participate in the proceedings, or failure, as I said, to possess qualifications. But independence and impartiality is the one that you see more often, or most often. And importantly, these are very difficult moments, right, where you're in the middle of a proceeding and they challenge an arbitrator. So there's a real time sensitivity to these. So parties have to act quickly, and usually there's a time limit. So it's either 15 days by the time you discover a ground for challenge, or 15 days from the appointment of the arbitrator, where you have to challenge. But still, what we sometimes see is that these challenges are used not in the right way, but just as a matter to derail the process. And I wanted to show you just briefly some statistics on this. So here what you have is some stats based on the ICC, LCIA, and ICSID repository of challenge numbers. Now, don't be fooled by the bar graphs being almost as high as each other, because the legends are actually different. So on the left, you have the total number of challenges in a particular year. And you can see they go up to 50s and 60s. If you add them all up, they cross 60s. And then on the right side, you have total number of successful challenges. And in every single year, it's fewer than 10. So of the number of challenges that are filed, fewer than 10 are actually successful. What does that tell you? That tells you that by and large, in more than 80% of the time, what happens is the party files a challenge just thinking, I might have a shot at that. this really can derail the arbitration, because if the tribunal, the remainder of the tribunal, chooses not to proceed, then honestly, what do you do? So what does that then lead us to? That then leads us to classify attempted arbitrator challenges as a guerrilla tactic. So I wanted to give you some examples of that. So attempted arbitrator challenges, some examples of where there's a certain set of rules called the IBA rules on conflicts of interest. So that deals with when an arbitrator has a conflict to sit in a certain matter and when they don't, and when they can just proceed, even if there's some relationship. So for instance, there's an ICC case where the court actually rejected a challenge against an arbitrator whose law firm, so the arbitrator's law firm, had represented a party in a prior case, not an ICC case, for a subsidiary of the claimant in this arbitrator's case. So there was a time gap between the arbitrator's appointment and the law firm's representation on the prior matter, and this arbitrator was not involved in the prior case. The ICC court found that there was no problem with that. What I would say actually is that the last one, the arbitrator's relationship with the party's counsel, is the most prevalent one that I've seen. So Laker Airways is a very well-known authority. It's quite an old authority, actually. It's of 1999 of the High Court of England and Wales. And that's where an English court rejected a challenge to an arbitrator based on the fact that he was in the same chambers as the barrister instructed by the claimant. The challenge was actually made under the English Arbitration Act. And this same chambers setting is something that, again, gives rise to a lot of challenge grounds. But actually, the grounds are in terms of not, that situation is permitted. So by and large, you can have barristers from the same chambers. Law firms are actually different, but you can have barristers from the same chambers, and they're actually able to act. But people still use it as a basis to challenge. Another situation I've seen a lot in my own experience is where we act as co-counsel in one situation, and that becomes counsel arbitrator in another situation. The IBA rules actually doesn't preclude that, but people still mount challenges on the basis of that, and a lot of the times just to have a go. So challenges are seen a lot as guerrilla tactics. The penultimate point I wanted to talk about is local proceedings. So local proceedings are, again, a really common tactic, and I've probably seen this more than anything else I've discussed today in terms of what we see as attempts to sort of stop the arbitral process. So what you'll have is the pursuit of local proceedings as a guerrilla tactic in the example of either anti-arbitration injunctions. I'll deal with that in the next slide. Or you'll have local proceedings that are in breach of the agreement to arbitrate. Now, I'll pause there for a moment because there is a real question as to whether it is a breach, whether local proceedings commenced in the sake of an agreement to arbitrate is genuinely a breach of the agreement to arbitrate. In some cases it is. For instance, if I've got a claim for breach of a certain contractual provision, of course that contract has an agreement to arbitrate. If I go and file a suit against that, what am I doing? I'm ignoring or disregarding or repudiating the agreement to arbitrate. That's a guerrilla tactic. Unless you have a very good reason, if you think the agreement to arbitrate is not valid, then that should be shut down and you should come back to the forum you've agreed to. But what about in other cases, say specialized tribunals, like you have the National Law Tribunal, you have the, the IBC, the Insolvency Code, where you can go to the NCLT for very valid, non-arbitration related petitions. This interplay between winding up and arbitration in particular is a whole other topic. But the only thing to say here is that by and large, are used as tactics, but it's not always clear. Sometimes there's a genuine basis for it. So again, it's on the forum in that court and the tribunal to decide, is this offending my process and the party's agreed process, and how do I stop that? So a third facet to local proceedings is actually not proceedings in respect of the complaint itself, but other proceedings. So say criminal proceedings or investigations. There's a very famous case of Neil Kaplan QC, who some of you might know. He's a former judge in Hong Kong. He was prosecuted in Thailand at the instigation of a party after he signed an arbitration award in Bangkok airport without having obtained a Thai work permit. So he was in Bangkok airport. He signed an award there, but he didn't have a Thai work permit. And you have to have a work permit to conduct yourself as an arbitrator in Thailand, at least until recently. And so he was prosecuted on that basis. Now, that's clearly not something that's to do with the arbitration process itself. It's just an attack in another way on the award. And I mean, in my view, that's clearly sort of conduct that is a guerrilla tactic. I had a case for an Asian corporation where they secured a successful arbitration award, and suddenly we had some English court proceedings filed against us, and we were asked by the other side lawyers to accept service. And we said, well, what's the case about? And they wouldn't tell us. They said, just accept service first. Because of course, in the English courts, once you accept service, then you have to go through the whole process of the English court before you even tell the court, sorry, this is the wrong forum. So what did we do? We just refused to accept service. The rules on service are very complicated in England, and we hid behind the rules of service because we knew that there would be something in there to do with trying to stop us acting on what was a favorable arbitral award. So again, they tried not to make it linked to the arbitration, but it was clearly a guerrilla tactic. A more extreme example of my colleagues is that we acted on a series of arbitration matters in a Central American state. And there was a local proceeding in the Central American state to injunct the arbitration going ahead. And my colleagues, so the lawyers of my firm, were injuncted from entering the country to defend those proceedings. So again, that is something that clearly isn't aimed at the parties of the dispute, but an indirect way of attacking the arbitral process itself. Now, those are all ways which, I would say are clearly tactics that should be stopped. But sometimes it's very easy to say that. It's actually very difficult to stop those tactics in reality. Let me just go through very quickly anti-arbitration injunctions. So anti-arbitration injunctions, arbitration is a creature of the parties' agreement, right? And so the competence principle comes with that. And that means the tribunal should decide on its own jurisdiction and should have the first right to decide on its own jurisdiction. But instead, what parties do is they sometimes rush off to a court, and court actually takes jurisdiction to decide should that tribunal go ahead or should it be stopped. And this is not something which is unique to any particular jurisdiction. It happens almost all over the world, where courts are very reluctant to actually decline the question of jurisdiction. And you'll only find the most robust of courts to say, sorry, but you should not come to me. You should go back to the tribunal first. But again, as a matter of procedural tactic, the problem is that that guerrilla tactic of filing in a local court can render a long process in the court before you can continue the arbitration. And I've had a situation where my arbitration was stayed. The tribunal decided to stay the arbitration until that matter was decided. And we were saying, well, first of all, you're competent to decide it. And secondly, you shouldn't stay even if you don't want to decide it. But we were not on the right side of that. So what you can see is lots of different ways where parties just find, and as I say, sometimes you take a step back and think, maybe that's genuine, or maybe the client is saying, you must do this for me, you must find whatever way you can to obstruct. But in reality, whoever initiates it and however it's looked at, something that objectively impedes the efficiency of the process, even though the parties have their opportunity to present the case, I would say that's a guerrilla tactic. So the last part of what I wanted to deal with is how do you then counter that? So there are some tools that I wanted to share. First of all, the drafting of the agreement to arbitrate. Parties should draft more precisely to avoid parties going off to court to challenge the agreements. Maybe pick a suit or a set of rules that you know will give the tribunal the mandate to proceed, give them a lot of power to proceed. Of course, now we know as a result of a recent Supreme Court judgment, Indian parties can agree Indian seats or non-Indian seats. So you've got a wide array to choose from in terms of what's the best way for my matter where I won't have lots of these impediments. Secondly, seeking interim relief before the right courts. So, for instance, trying to get an anti-suit injunction against some frivolous local proceedings to stop those proceedings. You don't always have to defend them in that country. You can stop them in the courts of the seat or before a tribunal. I would say one of the most powerful ones is case management. So being firm with the tribunal, holding a procedural conference early with the tribunal and saying, look, set this procedure, put some sanctions in there if someone doesn't comply. Don't leave any appetite for time extensions or procedural derailments, and just keep firm. In fact, we, as a result of some of our disclosure experiences, we actually decided on some cases that we don't want disclosure. So we just proceed without disclosure, and we push the tribunal to do that. So sometimes you have to hold the reins sort of and make sure the tribunal follows you. Two other more specific ones are managing document production. So this is, again, as I say, in the process itself, this is something that comes up a lot. And you do have document production problems that you should try and circumvent. My main advice on this is to include the IBA rules in your work in the arbitration right at the beginning. The IBA rules are very narrow on what is allowed by way of disclosure requests and things like confidentiality, privilege, all of that's covered. And finally, adverse inferences or cost sanctions. So maybe invite the tribunal to adopt rules that the IBA guidelines actually empower the tribunal to issue adverse sanctions or cost orders. And I would say parties should be more stringent on putting that in your procedure, on making sure that the other side is penalized in case you don't follow the mandate. I mean, of course, in the Indian context, the timing of the arbitration under the Indian Arbitration Act is now sort of bound to the 12 plus 6 months. But even then, what you see is parties coming up with genuine ways to sort of counter that by way of either local proceedings elsewhere or, challenges to arbitrators, or even Section 11 sort of petitions of appointments of arbitrators where the process hasn't even kicked off before you get to the 12 plus 6 months. So what I would strongly sort of encourage this audience, if you take away anything from what I've said, is identify the tactic. Sometimes you have to learn it from a prior case and apply it to the next, or learn it in your practice and come up with some best practices principles, and be firm with your tribunal. Take your tribunal with you, with the right tribunal, and this is really key to what I'm saying. You can control the process more, and certainly, your clients and your, team should have the impression that you have your mindset on this balance between what is the tribunal's duty and what are my rights. So that's what I had to say on guerrilla tactics, just by way of my experience and practical tips. Obviously happy to take questions from Anirudh or others. I should say that I have a hearing actually that's ongoing, so I may have to dial off in some time, but I'm very happy to, I hope that's been useful. I'm very happy to stay on for it.
Thank you very much, Sheila, for taking out the time and providing such a illuminating talk. We greatly benefited from it, and it's very nice of you, especially considering that you have an ongoing hearing to ensure that you sort of took out the time. If you have a few minutes, there are about 4 or 5 questions from the audience, if I may just put that.
Absolutely.
Yeah. So the first question is, can the usage of guerrilla tactics be limited through emergency arbitration?
It's an excellent question, because emergency arbitration is at the forefront of a lot of our minds. My short answer to that is yes, if used at the right time and in the right way. So emergency arbitration is something which a lot of rules have, but not a lot of courts or countries recognize in their legislation, India included. And so the real problem we have is you can get an emergency arbitrator, hold a very crisp and speedy hearing, get your interim relief right up front, but then you may have to bring it back into the country to enforce. Now, there's been a lot of divergent judgments here in India, there in India, about enforcement of emergency awards. But my own experience of emergency arbitration, even with India-related parties, is that parties have been threatened by the prospect of offending a tribunal. And if you have the right seat, so for instance, if you have a Hong Kong or Singapore emergency decision, you can elevate that to a Hong Kong or Singapore court order. So you're still offending a foreign court order, even if not a local one. And that is seen to have had a lot of sway in terms of recalcitrant respondents suddenly coming into line, or more frequently, what I've seen is matters tend to settle after that.
Thank you. That is very helpful. What are the remedies available to an arbitrator who is targeted? Are there any specific immunities that are available to an arbitrator, and what other remedies are available?
Yeah, it's very interesting territory, right? I mean, different jurisdictions had different protections for arbitrators. By and large, I would have said that globally, immunity is something that arbitrators do enjoy. Usually, the sanctions only go on arbitrators to the extent of costs. So, say even if they perform their mandate not to what was expected or contracted for, usually the implication is cost. I mean, of course, there's some parts of the world, like somewhere in the Middle East, where the sanctions were at some point more onerous than that, but that did get sort of cut back a bit as well. So what I would say is that arbitrators are more protected than parties and counsel. But in terms of actual harm, it's still a very difficult one because I, for instance, had a matter where, threatening letters were issued to the arbitrator, and annexed to submissions, even in the arbitration. There was no shyness about this. And what you found is that the arbitrator in that situation proceeded, but refused to hold hearings in the country of where the party was present, because they felt that there may be some risks of the type of Himpurna risks, that I identified earlier. So by way of advice, or the short answer is, by and large, if you're accepting arbitral appointments, try and know the regime of protection around you. But you may also need to get some practical advice of, say, not transiting Bangkok without a work permit, or don't issue an award in Bangkok if you're transiting, and also not choosing a jurisdiction or entering a jurisdiction which might be of risk for some time.
Thank you very much. And the next question is, on your example of Guerilla Tactics with Neil Kaplan in Thailand, how did that actually impact the outcome of the arbitration itself? If he had already signed the award, would it not have prejudiced the party which used those tactics and therefore backfired?
Yeah, so because he'd already issued the award, I mean, he's not for those of you who know him, he's not an arbitrator or judge who is fearful of tactics per se. So I don't think it got in the way of his own conduct of the arbitration. I think the real risk in that situation is that if the place of enforcement of the award is Thailand, then you have to work out whether that's going to be an impediment to enforcement or challenge if it's seated in Thailand. So in that situation, of course, I wasn't a party, but what the parties would have had to do is work out a way to avoid the jurisdiction where they have to enforce, or where there might be problems. It's actually a similar situation in Indonesia, where one of the awards was refused enforcement because it violated public policy. And the reason it violated public policy is because it found against the state of Indonesia. So again, it's a situation where you can win, but ultimately you haven't until you find another place to enforce. And so enforcement is a big driver for all of this.
Thank you. Next one, I think we have time for one or two more. What has been your experience as a counsel with regard to seeking an imposition of costs as a means to deal with the adoption of guerrilla tactics by the opposite party? Since most of these tactics are not per se illegal, for instance, frivolous challenges to arbitrator appointments, how open are tribunals to taking parties' conduct into account?
Yeah, excellent question, and really nicely phrased, actually. I think the main issue there is you hit the nail on the head with that question with party, because often that conduct is not per se party's conduct. Sometimes it may be, but sometimes it's actually counsel. So if you impose a cost order against a party for their counsel's conduct, is that really a fair punishment? Or is it, is it a punishment at all against the party who's really behind that conduct? What I've seen is that I have seen successful impositions of court orders in circumstances where there's been some threats. So it's almost like an unless order in a court. So you'd have the tribunal sort of saying, I give you one extension, a second extension, and in the second one, they say, that's your last one. If you come back again, you're going to have a cost sanction. So if you forewarn the party that that's what's coming, that's almost more impactful than actually imposing a cost order. And the other thing I would say about that, just quickly, is the embarrassment factor. And that's real. I mean, arbitration lawyers really care about their reputation, because appointments as counsel and arbitrators turn on that. So you don't want to be the person who's got a cost order imposed against you for your conduct.
Yeah, thank you. Then the next
I probably have time for one more, if that's okay.
Yeah, final one. So, do you have any comments on the Amazon case and whether that amounted to guerrilla tactics?
I'm afraid I can't answer that uh, with too much specificity. What I would say in general of court proceedings in the arbitration context is that it isn't always the case that just the mere filing of a court action in the face of an agreement to arbitrate isn't in itself a tactic. I think one really has to get into the granular. And what some sort of more high profile cases do tend to demonstrate is that sometimes it's not even for the outcome. I'm not talking about Amazon in particular, but it's not even for the outcome. It's for the mere consequential effects like the publicity effect or bringing parties to the table. So I can't comment on that case specifically, but in my view, it's a very difficult balance between actually advising. I've had to advise clients on, sometimes they've been very willing and keen to go to a court rather than the arbitral process. And it's been a difficult one a lot of times for factors other than just the legal analysis.
Thank you very much, Sheila. We've had a wonderful learning experience listening to you. I'm sure all the attendees have greatly benefited from the talk. I have for sure. Thanks a lot and look forward to being in touch.
No worries. Thank you so much for the opportunity. It was a real pleasure, as I say, and something, a topic and a venue and an audience is very close to me. So thank you for the whole thing, Anirudh and NCCI.
Thank you so much. And maybe I will join with Anirudh. I know you're hard pressed for time, but let me say a big thanks to you, JE, and probably Mr. Naveen too. As you mentioned, we are very happy to know about your Chennai Connect, and probably soon we will meet. Though the technology did this, we still miss the bonhomie and the friendliness. Hopefully, if not this year, next year we are sure to have you physically in our place. Thanks a lot, and you have made a brilliant presentation. As Anirudh said, you have said that all may be fair in love and war, may not be in arbitration. And thanks for probably pointing out the tactics, the one probably the borderline and the extreme, and beautifully answering the questions despite your time constraint. Thanks, Anirudh. Thank you for always being a support to the chamber for bringing us and also for moderating. And thanks to every participant, and thanks to my team, Madhumati, the registrar, and everyone here, the governing council members. Have a safe, good evening. Thank you.
Thank you all.
Thank you, everyone.